Silence, court rise.
In the Court of Appeal Criminal Division, the King against Thomas Edward Cashman.
Before you begin, Mr. Cooper, this is a case in which a reporting restricting order was made by the court below under Section 46 of the Youth Justice and Criminal Evidence Act 1999. Its terms have just been read out. It remains in place for the purposes of these proceedings, and for the avoidance of doubt, we make an order in identical terms.
I'm very grateful,
Thank
Lady, and to the court. This is a renewed application on behalf of the applicant Thomas Cashman, following a refusal by the single judge. I hope the court have had our most recent sentencing note, which was sent a week or so ago to the court and was downloaded or uploaded, whichever the right way around is, onto the system. And that sentencing note really encapsulates the submissions that we make today, and makes my submissions today before this court succinct, I hope, relying upon that particular note as the ground document for this application. I should also mention this in fairness to the Crown. I noted this morning there was a short response to this note from Crown's junior, Mr. Riding. I hope the court have had that.
We have. Thank you very much, Mr. Cooper.
As the court will know, this applicant was convicted on the 30th of March 2023 following conviction on all counts of an indictment which contained count 1, the murder of Olivia Pratt-Korbel, the attempted murder of Joseph Nee, the wounding with intent of Cheryl Korbel, and possession of 2 firearms to endanger life. And he was sentenced on the 3rd of April 2023 to the cumulative tariff of life imprisonment to serve a minimum of 42 years. We have read with interest and with assistance some of the recent authorities helpfully handed down by this court as to the approach they take to this sort of application and this sort of appeal. And I hope we have tailored our submissions in due course in accordance with what we're already aware of as to the approach of these courts to these sorts of applications. Can I effectively break down our submissions based upon this written document the court have into 3 sections? Our first submission is based upon our argument that the aggravating features taken into account by the learned trial judge in sentencing were too heavily relied on to increase the minimum term. And in particular, in that first heading, that the emphasis on planning and surveillance, whilst a relevant factor to take into account, of course it was, too much emphasis was placed upon it as to its sophistication. And therefore, whilst one can understand generally high levels of planning and preparation and surveillance potentially increase a minimum term tariff, as indeed has happened here, that increase was too much given this particular nature of planning and preparation. That's our first. And might I say, this is not in any particular order of reliance, it's simply to present it. That's our first a matter that we would argue before the court. The second is the failure to take into account any mitigation. Since, and I'll emphasize that, since the sentencing exercise, we became aware of the authority of Reeves, where it seems from that authority that a relevant aspect of mitigation is the age of a convicted defendant when they will be potentially available for release. And if needs be, I can take the court to the particular paragraph in brief if that assists in due course. But the essence of it is that if a defendant is available for potential release at a senior age, then that is a point of mitigation. And as far as this applicant is concerned, 33, 34, from memory at the time of conviction, he's going to be well into his 70s when he even becomes available for restricted release. That was not a point that seems to have been factored in to the sentencing process. I emphasise again, it wasn't a point that was submitted on because I wasn't aware of that point at the time, but it is, in fairness to the applicant, a matter we've indicated we wish to rely on as far as a mitigation is concerned. And as far as other aspects of mitigation is concerned, an overemphasis perhaps of the lack of remorse as far as the offence was concerned. And what we mean by that essentially is this. As the court know, the appalling facts that lie behind this tragedy is a chase by the defendant of Joseph Nee. The tragic death of Olivia Pratt-Korbel was not intended, and there was nothing we submit in the behaviour of this applicant at trial and after trial to indicate that he had lack of remorse in relation to her death. It is important, perhaps, for us to state this at the outset as far as that aspect of our submissions are concerned. The facts of this tragedy are that the applicant shot through a door in this young child's home. The fatal bullet went through the door. It wasn't aimed. And by the way, I know the court will know this. This is not an excuse for this appalling tragedy. It's simply me laying out the facts. The bullet went through the door. The fatal bullet then went through the wrist of the child's mother. And then that bullet went into the chest of the child. I recite those facts forensically, I emphasise, as I know the court will understand, but I wouldn't want to be misinterpreted by anyone as I'm trying to downplay the tragedy of this. But it does present, as far as legal argument is concerned, and a tariff, an important distinction from the sorts of cases that this court have seen, and have seen most recently, whereby guns and weapons are displayed, fired and discharged, even hand grenades in certain cases that I've read or we've provided. And a deliberate attempt of killing which results in murder has occurred. It was common ground during the course of this trial, and indeed during the course of the sentencing process, that this applicant had no intention to kill Olivia Pratt-Korbel. He did not know, and it was never suggested that he did, that this young child was standing at the top of the stairs when he undertook his appalling act of firing the weapon through a door which was half open. None of this is very palatable. I readily accept that. But it is in terms of a forensic analysis we submit of whether the tariff of 42 years is appropriate, irrelevant when one considers the facts. I am aware that the court do not take kindly to a simple analysis of other cases and comparisons of other cases and how they decide cases. And the only reason we have included a list of cases in our submissions, which I hope the court have had an opportunity to peruse, is the observation of the single judge, if I may respectfully say, when he refers to this case as notorious. It is important in our submission not so much to assist the court in coming to some form of guideline tariff, each case on its own merits. I understand the court's approach. But it is important that if an attitude is taken to a case, and words such as notorious and other words I can assure the court have been used about this case, the context of the facts of this case are important. And when one compares tariffs for cases, and I try to use my words carefully, for cases that have graphic levels of intent, let me put it that way, the court will understand what I'm submitting here, that result in tariffs of 35, 37, 38, with more obvious graphic levels of intent contained within them, and we've provided authorities as such. I can take the court to them, but I won't trouble them if it won't assist the court. Have the bond. The tariff of 42 years in the context of that sort of activity is, again, we submit, to some extent helpful to the court in getting a proportionate response in the application of the minimum term, as well as a just response, as well as a response from the court making it very clear on behalf of all of us and on behalf of society the appalling approach the court feel of this sort of offence. The third and final aspect of our submission perhaps is very much a subsidiary aspect and clearly has been the subject of the Crown's Junior's response this morning, and I understand the relative weaknesses of the point, but I do mention it and submit it at the end of our submission, and that is, although the learned trial judge made it clear she was not taking into account the absence of the defendant from the court when he was sentenced, it did seem, so far as it may or may not influence this court, and I realise the single judge was not the sentencing judge, but the single judge seemed to have included that aspect in his reasons for refusing leave. So our submission on that is restricted to this, that if the failure to attend court in any way influenced the single judge in refusing leave, and it seems that it did from what the single judge says in his remarks, then that refusal in our submission should be corrected and we at least be given the opportunity to fully argue our case on appeal.
It wouldn't follow, would it, that even if your submission were accepted, that you should be given leave, because whether you should be given leave depends on the merits of your substantive argument.
Yes. I understand the weakness, my lady, and I did hopefully reflect that in the way I pitched it, if I can put it that way rather elegantly, to the court. I raise it because there is always the perception, and I can put it no stronger than that as far as those that instruct me are concerned, that the highly publicised, and indeed it seems to have had political impact as well, of the failure of the applicant to attend for his sentencing, at the very least there's a perception that must have had an influence. I can put it no stronger than that, given the trial judge's remarks. Is, as it were, worthy of putting in as a third point. The single judge's response, including it as a reason not to grant leave, simply exacerbates that concern. But I'm not going to labour the point, but it is a submission we make as our third submission. So that's as it were, the skeleton of the way we put our arguments, and we do commend to the court our written submissions, which it's never attractive, of course, simply to read them, and I'm not going to. But we commend our written submissions to the court, which encapsulates what we say. Going back very briefly, just to supplement those submissions we have made. Aggravating features. Generally, there is an increase effectively from the 30-year starting point, which was accepted at the time by us and indeed is accepted now as the correct starting point. An increase of 12 years from that starting point. And I suppose the bold submission is that 12 years is too much in the context of this case. We respectfully remind the court, so far as it assists the court, and we understand again there is a limit to it, but it is relevant, we submit, that is the character and the antecedents of the applicant that the court have before them today. We refer to it at paragraph 17 of our written submissions, where his antecedents show 18 previous convictions for 33 offences, and save for one relatively minor offence of battery in 2010, there are no other offences of violence. He pleaded guilty to that at the Preston Magistrates Court and was sentenced to 120 days imprisonment. So the court are dealing fundamentally with a man who has no violence convictions to his name. But perhaps the essence of our argument is laid down as we try to put it easily referable to the court in our paragraph 21 of our written submissions, whereby, and I say with a degree of trepidation, hopefully the hyperlinks have worked and hopefully they have assisted the court, but we have laid down in paragraph 21 the full detail within the timelines of planning and preparation as far as this applicant is concerned. And I readily concede and accept, if concession is the word, that much of this application will hinge perhaps upon the attitude the court take as to whether the level of preparation, as to whether the level of planning was of such a high degree of sophistication and gravity to elevate a 30-year starting point 12 years onwards. And I accept again that part of that elevation is included in the convictions of the other 3 counts. But nonetheless, we submit, the elevation of the minimum sentence is unduly elevated with an exaggerated, if we may respectfully submit in relation to the trial judge's approach, an exaggerated account as to the sophistication of that planning. And the courts see, as we've laid it out, and should the court wish in their deliberations to refer to it on the case system, it's under the trial documents item 025, but we've distilled it in our document, but should the court wish to peruse it, that's where they can find it. The courts see what it is the Crown, and indeed the jury by their verdicts, must have accepted. That to begin with, there was on the day a degree of surveillance, 3 o'clock, then just after 3:25, and we've included in our bundle, and I'm not going to slavishly take the court through our bundle at tab 2, but we do respectfully refer this court to it, because what we've done there is extract from the timeline on the system at 0.25 the photographs and the CCTV of that very surveillance. And the court will see there, as we have referred to it in our document and as we refer to it there, this isn't sophisticated surveillance, it is walk-bys and drive-bys at times, some of them, as the court see in our section at paragraph 21, lasting for a matter of minutes. There is an element of face covering. It was disputed at trial, obviously, but that's not a point I can make here at this stage of the criminal process. But, taken again at its highest, it was face covering for a period of time, but not a complete period of time. And it was face covering at a time when we submit it was not necessarily significant to the fact that he needed to conceal his identity in any way. And indeed, there were photographs and pictures on the CCTV, I can tell the court, from the conduct of this trial, where he's seen removing his face covering, but a street later. I mention that not in mitigation to this court, of course not, but in terms of the level and proportionality of the approach to this planning and preparation. And again, we refer in our references in our written note and refer to the photographs and the footage again behind tab 2 of further journeys and drive-bys, and indeed checking where Mr. Nee was. We accept, of course, that happened. But the totality of that preparation and planning is recorded faithfully in our paragraph 21. And the court can see it takes up a side of paper. Now, I know this court, and I know this court both in their experience of the bench and indeed at the bar, will know that in similar cases like this, there's a far higher degree, most usually, of references to planning and preparation, some of it highly sophisticated. And our blunt submission here on it is that though there is a tariff to be paid for planning and preparation, the tariff here, in the context of the facts of this case, was too high. We have submitted effectively in our introduction on point 2 our arguments on mitigation, and in fact in my introduction I rather actually made the argument, so I won't repeat it again. But the court have our submissions that mitigation, available mitigation including age on release, was not taken into account, and that it was wrong, or at the very least excessive, to suggest that the remorse expressed for the death of this child was non-existent. We submit that was not the case, and we submit again the court can take into account the accepted position that there was no intention to kill, that the gun wasn't even fired in the direction of the child deliberately, and went to the door and the wrist, appallingly so, but the wrist of the child's mother, and then very sadly into the child. And we submit it is relevant when structuring an approach to remorse to factor that in. It would be a totally different situation in our respectful submission on remorse if the gun had been aimed at the child and the trigger pulled at the child and no remorse was expressed directly as a result of doing that. It is clear that the fatality here, criminally culpable and quite rightly so as it is, was not deliberate. I won't repeat my submissions on our third aspect. Those are, in fact, then our submissions. The written document brings them together and has enabled me to be succinct and shorter than perhaps I would have been had I not put those documents together. We do submit that, at the very least, we should be permitted by this court to argue this at full appeal, with the attendance of the Crown to assist this court on a matter which is obviously of importance to everyone. Unless I can assist the court any further, that's how we put it.
Thank you. We'll rise for a moment. Thank you very much.
Court rise.
This is a case in which a reporting restriction order was made by the court below under Section 46 of the Youth Justice and Criminal Evidence Act 1999. Its terms have been read out in court, and for the avoidance of doubt, we make an order in identical terms for the purposes of the proceedings before this court. On the 30th of March 2023, in the Crown Court sitting in Liverpool, Thomas Cashman was convicted following a trial before Yip J and a jury of all five counts that he faced. First, the murder of Olivia Pratt-Korbel, count 1. Secondly, the attempted murder of Joseph Nee, count 2. Thirdly, the wounding of Cheryl Korbel with intent to cause grievous bodily harm, count 3. And finally, of 2 counts of possessing firearms with intent to endanger life, counts 4 and 5. On the 3rd of April 2023, he was sentenced as follows: to imprisonment for life on count 1, with a minimum term specified of 42 years, less 182 days spent on remand; to imprisonment for life on count 2, with a minimum term specified of 22 years; to 10 years imprisonment on count 3, and to 18 years imprisonment on each of counts 4 and 5. All sentences were concurrent. The applicant's total sentence, therefore, was imprisonment for life, with a minimum term specified of 42 years, less 182 days spent on remand. The applicant now renews his application for leave to appeal against sentence, following refusal by the single judge. The circumstances in which these offences occurred are notorious. The serious injury by shooting of Cheryl Korbel and the fatal injury of her daughter, 9-year-old Olivia, by the same bullet that had already seriously injured her mother, occurred in the Korbels' home in Liverpool, whilst the applicant was chasing and attempting to murder Joseph Nee. The salient facts were summarised by the trial judge in her sentencing remarks in this way. All 5 offences arose out of the events of the 22nd of August 2022, when, armed with 2 guns, the defendant set out to kill Joseph Nee. He lay in wait before opening fire in a residential street. CCTV captured him standing over Mr. Nee, shooting at close range. When the first gun malfunctioned, Mr. Nee was able to scramble away, but the defendant had a second gun ready. He relentlessly pursued Mr. Nee, causing him to seek refuge by barging into the home occupied by Olivia's family. Undeterred and wholly unconcerned for the safety of others, he continued to shoot at Joseph Nee, firing into that family home. Olivia, just 9 years old, heard the commotion from her bed. Unsurprisingly, she came downstairs to seek the comfort of her mother. Her last words were, "Mum, I'm scared." In a terrible twist of fate, she had stepped directly into the line of fire. As her mother battled to keep the front door closed, the defendant fired a shot that passed straight through the door, then through Cheryl Korbel's wrist and into Olivia's chest, killing her. The defendant then managed to get his hand inside the door and fired another shot inside the house. Fortunately, the door was closed on his hand and the bullet discharged into the door frame, avoiding the people inside. As the judge observed, the killing of Olivia shocked not only the city of Liverpool, but the nation. Cheryl Korbel was a wholly innocent woman, unconnected with Joseph Nee, who had opened her door to see what was happening outside. Despite the terrible pain inflicted on her, she had fought to keep the trouble outside and had desperately tried to save Olivia. Emergency services arrived swiftly, but they were unable to save Olivia, who died later that night in hospital. Miss Korbel was unable to be with her daughter when she died because of the emergency treatment her own gunshot wounds required. Mr. Nee, too, suffered serious gunshot injuries. His shooting involved a significant degree of planning and premeditation on the part of the applicant, which went well beyond the premeditation that many, if not most, murders involving the use of firearms involve. The applicant had sourced not one, but 2 guns, presumably to allow for one misfiring. He knew what van Mr. Nee was driving, and as the CCTV footage amply demonstrated, he had been looking out for Mr. Nee earlier that day. The applicant spotted Nee's van. He changed his clothes and concealed his face and headed to the van, but by then it had left. Later, however, the applicant spotted the van again. Realising Nee was likely to remain where he was until the end of the televised football, he changed his clothes and lay in wait. Nee left the house he'd been in at about 10 p.m. He and a man he was with walked into the road where Olivia lived with her family. As they did so, the applicant ran up behind them and, using a 9mm self-loading pistol, revolver, fired 3 shots at Mr. Nee, inflicting a gunshot wound to his stomach, which he was lucky to survive. Mr. Nee escaped, was picked up by associates and taken to hospital before the police arrived. The applicant was arrested on the 4th of September 2023. He denied any involvement in the offences, a position he maintained throughout his trial. The judge ordered the applicant to attend his sentencing hearing, but he refused to leave the cells. The applicant is now 34 years old and is not of previous good character. He had 18 previous convictions, including for theft and kindred offences and for possession of Class B drugs. Though there was no history of violence, as the judge observed when sentencing him, the applicant made it clear during the trial that he was a criminal who used threats and violence when it suited him. In her sentencing remarks, the judge explained the approach she had adopted to the sentences for the individual offences so that the applicant and others would know how she had arrived at the eventual sentence she imposed. She said, however, the reality was that the offending could not be compartmentalised, and the minimum term to be served of 42 years less time spent on remand reflected the totality of his offending. Starting with Count 1, Schedule 21 of the Sentencing Act 2020 provides the statutory framework for sentencing for murder. The starting point under Schedule 21, paragraph 2(2)(ba), for the murder of a child involving a substantial degree of planning or premeditation is a whole life order. The judge said this did not apply to this case because the planning and premeditation was not directed at the child. Rather, it was the applicant's settled intention to do all that he could to murder Mr. Nee. That said, however, the seriousness of the murder, taken in combination with other offences, was particularly grave, such as to require a lengthy minimum term. The starting point in Schedule 21, paragraph 3(2)(b), for a murder involving the use of a firearm was 30 years. Having used this as the starting point, the judge then had to and did consider the non-exhaustive list of aggravating features set out in paragraph 9 of Schedule 21, together with any other relevant factors. First, there had been a significant degree of planning or premeditation, albeit directed at Mr. Nee and not Olivia. Secondly, though the judge did not necessarily accept the concession made that Olivia was a particularly vulnerable victim, whether she was or not was academic. The real gravity of this case was that a young child was shot and killed in her own home. As the judge put it, shooting into a family home with no regard for who may be caught in the crossfire was obviously a very significant aggravating factor to be reflected in the minimum term. Thirdly, none of the statutory mitigating features applied. Whilst there was no intention to kill Olivia, the fatal shot was fired with the clearest possible intention to kill, and this was premeditated. Had the applicant planned to kill Olivia, he would have faced a whole life term. Had he killed Mr. Nee on his own, the use of 2 firearms and the firing of shots into a family home would still have required a substantial uplift. The fact that Olivia was killed made the offence more serious still. Care had to be taken not to double count features that were common to counts 1, 2, and 3. The overall sentence had, however, to reflect that harm was not limited to killing Olivia, but included serious injury to 2 other people. As for count 2, the judge said had she been sentencing the applicant for this offence alone, she would have imposed a life sentence because of the obvious risk of harm that he posed to members of the public. This was a Category 2A offence within the relevant Sentencing Council's guidelines, with a starting point of 30 years and a range of 23 to 35 years. Even though a Category A case, the offence was aggravated by the planning, relentless pursuit of Mr. Nee, and the use of 2 firearms, so a figure towards the upper end of the range should be selected, but discounted by 1/3 to reflect the early release provisions which applied to a determinate sentence. For count 3, the offence fell into Category A2 within the relevant Sentencing Council guidelines, with a starting point of 7 years and a range of 6 to 10 years. The offence was aggravated by being committed against a woman in her own home, and a sentence at the top of that range was appropriate. The firearms offences, counts 4 and 5, were part and parcel of the other offences, and, said the judge, it would be artificial to consider them on their own. These were Category A1 offences within the relevant guidelines. Since the sentences would have no impact on the overall sentence the applicant had to serve, the judge simply adopted the starting point within the guideline for that category of offending of 18 years for each offence. The submissions now made on behalf of the applicant are in substance twofold. First, Mr. Cooper, King's Counsel, submits that the uplift from the starting point of 30 years of 12 years was too great and did not fairly reflect the facts of the offending, in particular the sophistication and level of the planning involved. In addition, there was a failure to factor in the absence of offending of violence in the applicant's background. Secondly, there was a failure to recognise as a mitigating circumstance that the applicant would be 76 before consideration could be given for his release on licence. In that latter context, in his written submissions, Mr. Cooper referred us to a number of decisions of this court, in particular the case of the Crown against Reeves, 2023, EWCA Crim 384. We can deal briefly with the first submission. Where the court passes a life sentence for an offence, the sentence for which is fixed by law, and sets a minimum term, Section 322 of the Sentencing Act 2020 requires the court to take into account the seriousness of the combination of the offence and any one or more offences associated with it. When setting the minimum term for murder, it followed that the judge was required to take into account the attempted murder of Mr. Nee, the serious wounding of Cheryl Korbel in her own home, and the consequence of the applicant's determination to murder Mr. Nee, which was the killing of a 9-year-old child when she had come downstairs from her bed to be comforted by her mother. This is what the judge did. She had heard the evidence during the trial. Her sentencing remarks were immaculately structured and well-reasoned, and accurately encapsulated the relevant aggravating features that were present. It was common ground that a starting point of 30 years for murder involving the use of a firearm was the correct one. The uplift of 12 years from that starting point represented a little over half of the sentence on count 2 alone. Having regard to the totality of the offending in this case and its seriousness, which the judge correctly identified, it cannot sensibly be argued that the overall sentence imposed was excessive, let alone manifestly excessive. Mr. Cooper, in his written submissions, though with less emphasis orally, sought to rely on a number of other decisions of this court to demonstrate that the overall sentence in this case was too high. It is sufficient to say that comparisons in the context of offending such as this are likely to be invidious and unhelpful. What was said in the Crown against Erskine 2009 EWCA 1425 by the late Lord Judge of paragraph 63 in relation to the citation of authority in a different statutory context are also apposite here. The principles for the exercise of the statutory power are set out in the statute. No further elaboration is necessary. Each case depends upon the application of the powers as set out in the statute in the context of specific facts in the individual case, no more and no less. As for the second argument, with respect to Mr. Cooper, we do not consider the authority of Reeves as of assistance either. It is not authority for the proposition for which it is cited, viz. That old age on release per se is a mitigating factor. No point of principle arises, therefore, which assists the applicant or this court. The sentence imposed by the judge was a long one. It means that the applicant will be well into his 70s before he can be considered for release on licence. That, however, is a consequence of the commission by him of these terrible crimes, rather than of any error of approach on the part of the judge. The applicant invaded the home of a family in his determination to execute Joseph Nee, who he had already shot. He then murdered, by shooting, Olivia, a little girl of 9, and seriously injured her mother. These events have left Olivia's mother and her family with a lifelong sentence of trauma and loss. There were no mitigating features. There was no remorse. The sentence ultimately arrived at was entirely merited on the facts, and the contrary is not arguable. The application for leave to appeal against sentence is refused.
I'm grateful for my lady's the court's recent ruling on the matter. Just one hopefully helpful correction to my lady's recitation. In fact, the trial took place in Manchester, not in Liverpool. It originally was in Liverpool, but the venue was changed.
I'm grateful, Mr. Cooper. Thank you.
Court rise.